The moment you type the final punctuation mark on a manuscript, the purely creative phase of your work ends. Immediately, another phase begins. Your manuscript enters the legal and financial reality of the publishing world, where it becomes an asset to be managed. As we look at this stack of books, we are looking at the historical foundation of copyright law. Text and literature are the original terrain that intellectual property was designed to protect. The law exists to give the writer control over how physical and digital pages are shared. Yet, in practice, authors routinely face a serious tension. They are handed dense 50-page publishing agreements filled with legal terminology, and they sign them without knowing for sure if they are permanently selling their work or simply renting it out for a few years. Once the book is out and the money starts flowing, a second tension arises. Authors frequently mix the royalties they earn from their writing with the fees they charge for giving a lecture or writing a magazine column. By blending these income streams, they risk losing access to Belgium's highly favorable copyright tax regime. To protect the legacy of your creative labor and to optimize the money it generates, you have to master the dual matrix of publishing. You must control the legal rights to your text and strictly classify the fiscal nature of your income. Every time you negotiate with a traditional publisher, a digital distributor, or a self-publishing platform, you face a primary legal decision. You have to decide exactly how you are going to transfer your rights to them. In legal terms, you can assign your rights, a definitive sale. You permanently transfer ownership of economic rights, like printing or translating, to the publisher. Alternatively, you can grant a license, a rental agreement. You authorize the publisher to exploit your work for a defined period, but retain ultimate ownership. When the contract expires, control automatically returns to you. This distinction requires deep vigilance, especially with digital self-publishing platforms. Before clicking Accept on a Terms of Service page, check the exact scope of the rights they demand, and look closely to see if they are asking for exclusive control over your text. Choosing between assigning and licensing dictates the exact degree of control you retain over your life's work. It determines whether you are divesting yourself of an asset forever or establishing a recurring stream of revenue while keeping the property in your name. If you choose the traditional publishing route, the relationship is highly regulated by Belgian law. A publishing contract is a reciprocal commitment requiring specific actions from both sides. The publisher cannot simply lock your manuscript in a drawer. They have a strict statutory obligation to genuinely exploit the work, manufacture copies, and bring them to the public. If they fail to do this within the agreed timeframe, you have grounds to take your rights back. This transparent ledger represents the publisher's legal obligation to regularly render accounts, eliminating the mystery of the phantom print run. When you sign, you may receive an advance. Legally, this isn't a flat purchase price. It's a prepayment drawn backwards from your future expected royalties. You are paid from your own future success. The law builds these specific rules into the publishing contract because it presumes the author is the weaker party in the negotiation. These rules exist to protect you against financial opacity and to ensure your work actually sees the light of day. Once your book is on the market, your focus has to shift from civil law to tax law. Belgium offers a highly favorable tax regime for copyright income, but qualifying for it requires strict discipline in how you manage your money. To satisfy the tax administration, you must ruthlessly separate your income into two distinct buckets. The first holds pure copyright income, advances and proportional royalties from assigning or licensing your rights, eligible for favorable movable income rates. The second bucket is for ancillary services, like speaking fees or workshops. This remunerates a service, not intellectual property, and follows standard progressive tax rules. If you mix these two streams on your invoices or tax returns, you invite scrutiny. Lumping service income together with royalty income is the fastest way to trigger a recharacterization by the tax administration, which can destroy your favorable tax benefit entirely. Every title in this stock represents a managed asset in a well-organized portfolio of intellectual property. Navigating this terrain requires 3 core actions. First, always scrutinize your contracts so you know exactly what rights you are temporarily licensing and which ones you are permanently assigning. Second, hold your publishers to their statutory obligations. Demand that they actively exploit your work and require them to provide the transparent accounting you are legally owed. Third, meticulously separate your royalty income from your service income. Keep your tax buckets completely clean and retain all of your signed publishing contracts to serve as proof of the transfer for the tax authorities. By mastering both the civil control of your text and the fiscal classification of your revenue, you secure your creative legacy and your financial future. Please note that this video provides general legal information. For guidance on your specific contracts or tax situation, always consult a qualified professional.